Thanks for coming back. If this is the third presentation you have watched on this topic, build it, protect it, and pass it on. So it is a series of 3 presentations. The first was the introduction, the second was the SMSF strategies, and this one is advanced protection strategies. So this one really is advanced strategies for people with companies, trusts, more complex structures. So if you haven't watched the first 2, I would suggest you probably watch those first before going on to this one. It will make a little bit more sense. Who are we? My name is Cass Smith. I'm the founder of Freedom Financial Solutions. Mary Jane is the managing director, and Grant Abbott is our consultant estate planning strategist. So what are we going to talk about? Well, let's start with the right questions. So do you have a clear plan in place if you die or become incapacitated? Do you want to keep your wealth in your bloodline? Do you have business or investment assets in your own name? Who will take over for you legally, financially, and emotionally? So with those questions in mind, let's talk quickly about what is an estate. I did cover this in the previous videos, but just in case for those that might have skipped straight to this one, what is an estate? Basically, it's all your assets, everything a person owns or is entitled to at the time of their death. So you can see in this little pretty picture, it's your homes, your jewelry, your watches, your cars, your cash at bank, your Bitcoin, gold and silver, everything in a nice little white picket fence. But this fence has a little bit of a gap in it and the sharks are circling. How long before those sharks find their way in? Your estate does not include your superannuation or your life insurance unless you have specifically nominated it to go to your estate. So how safe is your estate from attack? And what is at stake? So what's at stake is all your assets, your home, your savings, your business, your super, your bullion, your property, your shares, any other assets you've got. Your family's financial security after you've gone is at stake. Because if you don't get these basic fundamentals right, everything you've ever worked for could be taken. It's also your wishes and your legacy being carried out. If you have money, I'm sure you want it to go to those that you want to have it, and that it can be used for a purpose that you want it used for. And it's also really important to avoid family disputes, court battles, and tax traps. We'll talk more about that because there's some big disputes, family disputes, terrible, that tear a family apart and take all of the money and give it to the lawyers. And you also don't want the tax man to have your money. So what are your risks to your asset now before death? There's lawsuits. Somebody could sue you for an accident or in business. Divorce and relationship breakdowns. Assets could be split or lost. Financial troubles like bankruptcy or debt collectors can come after your wealth. You might make bad business decisions, personal guarantees or failed ventures that put your assets at risk. Or you could have poor insurance structures. If your assets aren't particularly insured, they may not cover the loss. Insurance companies do everything they can to get out of covering any losses. Or health issues, sudden serious illness, incapacity can lead to loss of income, and also rush decisions. You really don't want to be making rush decisions at a time of stress when you've been, say, diagnosed with something serious or mentally incapacitated. So some of the common vulnerabilities that we see is no enduring power of attorney, no will or an outdated will. Assets held in your own name is a big risk. No plan for blended families, former partners, and potential claimants. Children inheriting too much too soon. I personally believe children should not have the money till they're over 30, maybe even later. Superannuation not being covered by your will, and exposure to divorce, litigation, and creditors. That's also exposure of your beneficiaries. So you don't want your money left to a beneficiary who maybe is going through a divorce or litigation, so all your hard-earned wealth ends up in somebody else's hands. So who wins in a challenge? I love this question. I covered it in the last one, but for the sake of it, who wins in a challenge? You, maybe. The person who's got the most money so they can pay the best lawyer, maybe. The best lawyer, maybe. Who actually wins is the lawyers. The lawyers get the money and at the expense of the beneficiaries. So some cases to go through. It just gives you an example of the sort of thing that we're talking about. Co-op versus co-op. The deceased had left his entire estate of approximately, it's only 1.4 million. I say 1.4, that's a lot, but a lot of people will have that when they die. He omitted his adopted stepson, who later became severely disabled. The stepson was awarded 600,000 of that, and the widow was forced to sell the family home, and the legal costs were 150,000. The deceased's 5 other natural children did not contest the will and received nothing. Their future inheritance was effectively extinguished. So Curtis versus Curtis, 2 grandsons contested their grandfather's will, which had left the estate of approximately 620,000 to his son, but not the grandson's father. Okay, complicated family arrangement there. The Court of Appeal overturned the initial judgment that favoured the grandsons, upholding the original will. While specific legal costs are not available, such appellant proceedings can incur substantial fees, potentially exceeding 100 to 150,000, which would come out of the estate. So effectively, these grandsons, they didn't win from the looks of it, but it just cost the estate 150,000. Copperwick and Miltola, the deceased died intestate, which means without a will, with an estimated estate of between 550 and 1 mil. His partner and her son sought provision from the estate, which otherwise would have passed to his mother. The court allowed the partner and the son to claim the provision, likely 200 to 400,000, altering the distribution under the intestacy laws. Legal costs not available, but assumed over 100,000 out of the estate. And the natural family received a reduced share of the estate. So once again, this is just, died intestate is just, you really don't want that to happen. And anyone out there who hasn't got a will, at least get a basic one. You don't want the government coming in and deciding who is going to get your money. Next case, the estate of Capellan. A caveat was filed to prevent the probate and a potentially invalid will. The court reviewed the 2020 will, stressing the importance of proper execution and testamentary capacity. That's whether you are still mentally competent when you've written it. The family faced delays and likely reduced inheritance due to legal costs. The exact figures weren't published, but the dispute would have been financially draining, each party's fees typically ranging from 50 to 150,000. A few more, estate of Mimi Milker, Berger, multiple conflicting wills and codicils led to disputes among relatives, friends and organisations of over a $24 million estate. The court upheld the 2015 will in favour of the niece and the grandnephew, dismissing all other claims. While legal costs were not published, fees estimated between 800,000 and 2.5 million. High value estates with multiple contesting parties typically incur extensive legal fees. The estate was significantly depleted by these costs, and natural family members received less than they would have otherwise expected. Sun versus Chapman, a de facto partner who had lived with the deceased for about 20 years, but was not provided for in the will, with an estate value of approximately 2.58 million. The Court of Appeal recognised the de facto relationship and awarded her 550,000 from the estate and ordered the estate to pay her legal costs of 267,000. The total estate would likely absorb 450 to 600,000 in legal fees. That's a quarter of the estate. Lawrence versus Martin, a de facto partner of 16 years was left out of the deceased will, which predated their relationship. Must have been a very old will. For an estate of approximately 1.6 mil, the court awarded her an additional 350,000 from the estate based on her contributions and future needs. She had already received 229 in life insurance and a benefit from the jointly held family home. Legal fees were likely 100,000 to 200,000, further reducing the inheritance available to the deceased's son. Last one, the estate of a sim. The sole director and shareholder of a real estate agency died intestate, leaving the company with no authorised person to act. The result in frozen trust accounts and a complete operational standstill. The court granted temporary letters of administration to the deceased daughters, allowing them to appoint a new director and resume business operations. Legal fees were estimated to be 80,000 to 150,000, but, and I know this from my own business history, additional losses from business disruption during the freeze. So you're operating a real estate agent, you've got houses in the middle of being sold, maybe an unconditional contract going to settlement, maybe many of them in this period, that could have been significant legal fees if there was damages and lawsuits from clients who had financial problems because of your business being frozen. So real protection requires up-to-date, clear and watertight instructions, removing assets from personal ownership and using smart legal structures like companies and trusts. Let's start with your company for those that have one or are considering one. So why use a company? It's a separate person under the law. It can be used for trading, saving up dividends from trusts, managing family trusts and retirement funds. It can borrow money, own property and sue or be sued in its own capacity. It can protect personal assets and it has tax benefits. And it continues to operate even when the owner is incapacitated or dies. And that's important because you die or suddenly become incapacitated, that company continues to own all the assets, continues to trade, it continues. So it's really important to have a plan for that. So things a company director must know. If you're a company director and you become incapacitated, are sued or die, your company may face serious operational and legal problems. Why? Because your directorship automatically ends when you become incapacitated and obviously when you die. If you're involved in legal proceedings, personal liability may affect the company even after your death, particularly if you're the sole director and shareholder. There's an ASIC guidance statement number 73, which highlights these risks in warning sole directors and small business owners to put appropriate safeguards in place. So what are some of the appropriate safeguards? We will be talking about those, but with multi-director companies, you might think, well, okay, well, I've got multiple directors, so it doesn't matter so much. Well, yes, it does, because, well, it's better because the other directors can continue running the company, but business decisions could still be disrupted if you're essential to operations or the decision-making, such as being a sole signatory on things. And if you're incapacitated, the board or the other directors may remove you as a director under the constitutional shareholders agreement, and you may need legal advice on company may need legal advice on how to replace you depending on the circumstances. But also those new directors or the continuing directors may operate the business in a way that you don't agree with, and it could seriously jeopardize your wealth, being your value in that company. So if you're incapacitated, you still own the shares, and your enduring power of attorney can manage your shareholder rights like voting and transferring the shares. And on death, your shares form part of your estate and are distributed according to your will or intestacy rules if there's no will. So once again, it's important to protect the value of those shares by having appropriate strategies for that company to continue operating in a way that you would like it to keep operating. So if the control of the company is tied to the shares, such as majority ownership, it can create conflict and delays as you move forward with the estate. So back to the sole director company, when you become incapacitated or die without planning, the company is effectively frozen. No one can access the bank accounts, pay wages, or make decisions. So if that company is valuable, all of a sudden could lose a lot of its value or all of its value if it all of a sudden can't trade and can't pay wages, because then all the staff will walk out the door, and then what company? Okay, so ASIC doesn't automatically appoint a new director. The estate must apply to the court to appoint a new director, which can take weeks or months. In my experience, it'd never take weeks. It would take months. And it's a complicated scenario, 12 months. So your whole company can go down in flames if you do not have a successor director. So with planning, your will can provide provision about your shares, such as who's going to own them, but directorship needs planning, such as a successor director clause in your company constitution or via a special appointment, which allows someone to step in immediately. This is very important for every company that anyone is operating, that they have a successor director in writing, ready to go in case anything happens. Because what if no one is authorised to act for a company? As I said before, it will be completely unable to operate. No one can make management decisions or act on its behalf. Banks may freeze. It's unable to trade or continue day to day. Business, staff and suppliers won't be paid, quickly damaging the company's reputation and value, reducing what's left for the beneficiaries. So, summary and solution. The ownership of the shares can pass via your will or your estate plan. The director control if you can hand over the control, they can have legal authority and act immediately. Your business operations can be disrupted if there's no plan in place. The solutions for the family and the SMSF trustee and the businesses with vulnerable beneficiaries include the successor director strategy, which we can easily implement for you. A shareholders agreement, which we can also draft up for you, and a testamentary trust or a family protection trust for shareholding. So the actions to take are, enduring power of attorney to make sure it allows someone to manage your personal and financial affairs. A will to make sure it addresses what happens to your company shares and your trusts for their shareholding. Company constitution, make sure it allows for an enduring power of attorney to act as a director. And the successor director solution. If you're the sole director, make sure you have a successor director set up to give someone the legal authority to step in immediately. Even in a multiple director situation, you might want a successor director to take over your role to make sure your other directors don't go and do things that you don't want them to do. And a business continuity plan, especially for essential roles like business owner-operators or sole trustees. So a business continuity plan either can be, if you're a sole business director, you can have a written up plan so that in the event of something happening to you, your beneficiaries or your enduring power of attorney actually knows something about the business and can keep it going to enable it to be sold or get some value out of it. Or if it's a multiple director company, you could have a business continuity plan so that the other directors have some guidance on what you want them to do. So what about other stuff? Lots of other stuff in that chart, and now the fence has got lots of holes in it and the sharks are getting closer and closer. So is your estate safe from attack? So most people hold assets in their own name, which then forms part of the estate on death. We'll come back to that because holding assets in your own name is not necessarily a good way to go. So ask yourself a question, the bloodline question. On a scale of 1 to 10, how is it important to you that your wealth stays only in your bloodline? Bloodline is your own direct blood children. Did you know that giving money to your children now could see it lost in divorce under the Family Law Act? Even a 2-year de facto relationship can turn assets into shared matrimonial property. 2 years, I've actually heard 6 months in some areas, so just be careful. When a child inherits and then dies without a trust or a bloodline plan, their spouse and even stepchildren may end up with your wealth. So very important considerations. So who might attack an estate? Look at all these people and things. Disinherited children, estranged children or siblings, current or former spouse, de facto, stepchildren, other blended family members, hungry litigators, no-win, no-fee law firms, estate litigation specialists, entitlement whisperers. I haven't heard it called that. So basically the no-win, no-fee lawyers, they go out there and they hunt down estates and they search for beneficiaries that might be able to attack the estate. Creditors, like unsecured creditors, the tax office, Centrelink, financial and business partners, former employees and contractors, banks and lenders, co-executors, trustees of trusts, caregivers or companions, charities and beneficiaries and old wills, friends and neighbours, or the public trustee. So it's very important to consider all of this. You don't want those people on that list having anything to do with your estate, all the wealth that you've worked and built. So estranged children and siblings, they often feel they've been treated unfairly. And if they're already estranged, they're likely to attack the estate, particularly if it's a no-win, no-fee lawyer that's convinced them to do so. Stepchildren, I mean, you might want to leave money to stepchildren, and that's fine, but maybe you don't. So one way of getting around this is instead of having money in your estate, have it in a trust, because a trust becomes a much more secure vehicle that people are much less likely and not able to attack. And it can protect your wealth for generations to come. So when you die and things go into your estate, that eventually gets wrapped up and paid up. But a trust, you can die and that trust can continue to operate for years, if done right, generations to come. So why holding assets in your own name is risky? There's a number one saying that I have certainly adhered to since I went through situations in life where I lost all of my assets several times in several divorces and in a bankruptcy and liquidation. And ever since then, I learnt my own lesson and took my own advice, and don't own any assets in your own name. It's called control everything but own nothing. So the tax system encourages you to own assets in your own name because you get capital gains tax exemptions on your home and negative gearing on properties. But I would suggest, and don't take this advice 100%, it is different for everybody. But if you are in business or want to protect against marital partners, it can be very valuable not to own your own home or any properties in your own name, but to hold them in trusts. And that's certainly what I would do. If you're a legal target, anyone suing you can go after assets in your own name. Putting them in the spouse's name isn't a good idea either, because more than 50% of relationships end up in divorce, and even if you think your relationship is absolutely hunky-dory, it may not be in 5 to 10 years' time. So even a will with testamentary trust doesn't guarantee protection. They can be challenged by anyone who believes they were left out and unfairly treated. So what that means is, what we're talking about is putting it into a trust now while you're still alive, rather than leaving it in your will. So the solution is a leading member and family protection trusts. So I don't know why, but Grant, who gives us a lot of this information, seems to love the royal family and bases a lot of the acronyms on the royal family. So just like the British royal family, the trusts are built on a clear line of succession to make sure that everything stays in the bloodline, with a central figure controlling how it is passed on. So the leading member is the custodian of the family's wealth, who is the guy who makes the guiding decisions and protects the trust long-term purpose. A leading member discretionary trust or a family protection trust operates with the same intent: preserve control, protect assets, and ensure wealth stays in the right hands. The leading member holds decision-making power, but on their death, incapacity, or voluntary step-down, due to litigation or family law, a nominated successor takes over immediately with no disruption. So as I said, these are advanced solutions. They're not for everybody, but they certainly are very effective for the people who need them. So all distributions of income and capital are restricted to bloodline beneficiaries only, preventing wealth from being diluted through remarriage, divorce, or third-party claims. So we can also have a leading member SMSF trust, where as a leading member, you get to decide something happens to you, you get to decide who is the leading member that steps in and takes over. So it's the ideal superannuation trust that gives centralised control through a leading member, avoids power struggles, and stops the in-laws or second spouses from taking over after you've gone. It gives bloodline protection to super assets. It stops the money leaking to non-family members in second marriages, blended families, contested estates. It gives very flexible succession planning. Your fund won't freeze when someone dies or becomes incapacitated. There's always a clear legal line of authority. It has integrated legal powers to remove problematic members. The fund remains functional, compliant, and protected without court battles and family fallouts. It's enhanced estate planning integration. The super becomes a smooth, tax-effective part of your family long-term wealth plan, not a contested mess. So here we have what we call the Kensington Palace of Trust, which is a leading member discretionary trust. So it's like a normal discretionary trust, but the leading member, the main person that's controlling it, gets to decide what happens when they pass, but also keeps good control while they're still alive as well. So it's a centralised family control with one leading member, LMA, at the time, and ensures strong, focused leadership and succession across the generations. It's got robust asset protection. It safeguards the family wealth from litigation, bankruptcy, and family law disputes and divorce. It's a future-proof structure. So on death, the trust splits it into sub-trusts for each child, child 1, child 2, child 3, with no CGT or stamp duty implications. So that's fantastic. The idea of these trusts, as I mentioned before, is that they can go on for generations to come. So the assets can stay there, and instead of having to be sold and transferred and have capital gains, if they all stay there, the income can keep coming in and the family wealth can keep building up for generations. So it's intergenerational control. Each child becomes a leading member and director of their own sub-trust, securing the ongoing control for the whole family. There's tax-effective, business-friendly structures. It supports family business operations and tax planning with flexibility to include underlying companies that don't compromise the trust integrity. What that means is, from the picture, you can see that we can have something called a bucket company, which I always love that term. It's basically the bucket where everything ends up in, or operational companies, and we always keep operational companies separate from bucket companies and separate from landholding companies and separate from asset companies, so that everything is separate so that it's protected. Yes, as I said, these are complicated strategies and they're not for everybody. And you're not expected to understand everything I'm saying. You could watch this video again and again if you want to learn more, or come to us and we can set it up for you. This is not all. We then have a Buckingham Palace of Trusts, which is a family protection trust, which I have heard about for a very long time. And I have seen people set these up, some with success, some with not. Very, very complicated, but very, very powerful if it is what you need. So it is ideal for family protection, for the family jewels. So it's built for generational control. It makes a clear line of succession that ensures the decision-making stays with the family through each family protection appointer. So that might mean mother or father is the first appointer, family appointer, but when they pass, it's then the oldest son, and then it's another, then it passes, and it can just keep going down generations. Strong legal protection. It shields assets from litigation, bankruptcy, and family law claims, even decades, even generations into the future. It's a tax-effective structure when properly set up. It delivers significant tax savings and flexibility across the whole family group. There's automatic sub-trusts on death. So that is, the estate is split into, you can have, each child can have their own sub-trust without capital gains and stamp duty. And it's ideal for holding business intellectual property or assets. And companies, as I mentioned on the last slide, trading companies, asset companies, bucket companies, intellectual property companies can sit under the trust, and they won't create a risk and contaminate the structure by debt and guarantees. Will with testamentary trust. I tell a funny story about this one. I learned about wills and testamentary trusts when I was a little wee 19-year-old in university learning accounting, and heard about these, and I ran home to my mum and said, Mum, you've got to get a will. My nan's will done. Make sure we have family testamentary trusts. Oh, of course, she didn't listen to me. She never does. But I did make sure she did put one in hers, because it's the bee's knees. Better than sliced bread. There's two things that I really, really love in life, well, in my professional life as a professional advisor, and that is SMSFs and wills with testamentary trusts. I could talk about it for a long time, but I'll get on with the slide because I do have to wrap this up. So it's the same as the family protection trust, but it only comes into existence upon your death. So it's in addition to your will, and it protects the family wealth from divorce, de facto claims, and step family dilution. The number one thing to me is that I'll give you an example. If I was to pass away right now and all my money just went into my will and then out to my children, I have 4 children, adult children, and 2 of them have been living with their partner for longer than 2 years, and the relationship may or may not be solid at the time that I die. My wealth that goes to that son could end up be taken when they separate from their partner. That's not what I want. So if you leave it to and it also not just partners, if they were going through a bankruptcy or creditors or anything that was happening in that child's life, I don't want anyone taking that money. So it goes into a testamentary trust and it gets held there. The children can still access it when they need it, or they can invest it and grow wealth for their own family and themselves, but protect it from anyone else. So it shields assets from creditors, lawsuits, bankruptcy, and beneficiaries. It gives control over how and when inheritors are used across generations. It allows the automatic sub-trusts. So each child can have their own sub-trust without the capital gains and stamp duty. Tax advantages, so there's adult tax rates for children under 18. I can go into that at length, but not today. But just quickly, the family could leave all the money in the testamentary trust, invest it and make money, and distribute it to the children under 18, up to about, at the moment, $22,000 in income each year, tax-free. So that's an amazing thing to be able to do. So that money could then be used, for example, for the children to go to private schools or university or something like that, and it's all tax-free money. Okay, it can support vulnerable beneficiaries with tailored distributions. We could also build you a castle. So we do a product called a moat and a castle, and a strategy called a protector. The protector strategy. This is the next one, and this is the most complicated strategy. So the protector strategy is designed to move your personal net wealth into a secure family protection trust, separating it legally from your own name. The family protection trust is designed so only your bloodline and their related trusts and companies can benefit, excluding ex-spouses and outsiders. Your personal assets, excluding the SMSF and trust assets, are gifted to the trust through a deed of gift backed by a formal loan agreement, a promissory note. The trust lends that money back to you with minimal interest rate or no interest rate, payable only at the end. The loan is structured with a mortgage over your home or property, giving legal strength to the strategy. There's no capital gains or stamp duty to this transfer. So what does that mean in a simplified term? It means that all your assets, including your family home, your investment properties, your shares, even your car, your jewelry, anything that you want, can be gifted to this trust, put into the trust secured by a mortgage, then you get the money back via a loan. So nothing changes, actually. In your personal situation, nothing changes. But there's a whole lot of really complicated paperwork in the background so that you effectively now own nothing. So often when there's litigation involved, the first thing a fancy lawyer will do will be a asset search to see what assets you have in your own name. And if that lawyer sees that, hey, they've got no assets, then people are very much unlikely to take legal action against you because the lawyers know that there's nothing to get. And in that case, if somebody did take legal action against you, you could just file for bankruptcy and walk away because all your assets are protected in a trust. Fantastic strategy. It's not for everybody. Not everybody needs it. Some people have nice little simple lives and they don't do anything that puts them at any risk whatsoever, like they never get married or they get married and it lasts. I shouldn't be so sarcastic. Yeah, anyway, moving right along. So the result, your assets are shielded from lawsuits, bankruptcy, and family provision claims. So we also have something called a waterfall will, where the will maker dies. The waterfall will directs all the assets into a multi-layered structure and ends up in a family protection trust. Superannuation death benefits are left into that trust, not directly to the individuals. Personal estate assets go into the trust. The Family Protection Trust acts as a central vehicle for long-term control, asset protection, and tax effectiveness. The Family Protection Trust holds the family's wealth in a protected structure rather than distributing it. And upon a triggering event, such as a death or a certain age, the Family Protection Trust can then split into subtrusts for each child or each bloodline, and each child becomes the family protection appointer of their own subtrust. The entire flow is designed to preserve wealth, maintain bloodline control, and avoid CGT and stamp duty. So we also have a guardian strategy, and that is basically anyone with young children or vulnerable beneficiaries or blended families or significant assets should consider appointing a professional guardian. And here's why it can make a difference. So people can be a guardian, they're SMSF accredited, and people like myself and Mary Jane are accredited guardians. So we are independent and impartial. We can reduce the family conflict because we unbiased decision making, even just down to the point that we are trained in conflict resolution and ethics, so that when we're looking at something, the children might be arguing over something, but we just remain impartial and independent. With legal and financial expertise, we can navigate complex rules and protect entitlements and protect vulnerable beneficiaries. I used the example in the last video about in my 4 children. I can imagine them all arguing because some of them are more dominant than others and might be stepping over the others and saying, oh no, we've got this, we'll control this, to the detriment of some of the less outspoken children. It's accountable and transparent. The guardian can make sure everything is done with professional oversight and long-term stability. The guardian can be in place for 10, 20 years. So it can just be, like that sound, wise person that the family turn to when they've got an issue they need to talk about financially with the wealth. So what's next? Ask yourself, if something happened to you yesterday, did you have a simple, clear strategy that helped your family know what to do? Who would take over your business and financial affairs? Do you have a blended family, former partners, or complicated family dynamics that could lead to conflict? Do you have a disabled, disadvantaged, or elderly family member? Are your EPOAs, wills, trusts, companies, and superannuation nominations all aligned and up to date? And are you using structures that minimize tax, protect wealth, and prevent delays in distribution? If you have no instructions, your estate will end up with whatever family member the government can find. If you have absolutely no family, it will get left in the government's hands, and I'm sure nobody watching this wants that. And if it's not what you want, if you've got no family, don't just ignore the problem and go, well, I've got no family, so who cares? I'm sure you still don't want it in the government's hands, so pick a charity, and we have set up a charity for those that don't have a favourite charity or those that are concerned that the charities out there use the money to pay their own executives. We have set up our own charity, Holistic Future Solutions, to look after the medically injured out there, of which we all know there are a lot. So what does it cost and what does it save? Focus more on what it saves, because yes, setting up the proper legal structures will cost a few $1,000s, no doubt. But it can save you hundreds of thousands of dollars in unwanted claims and legal fees. So consider the cost to your family of doing nothing. Long and costly lawsuits, family disputes. You don't want your children or your family arguing after, and money does strange things. So people, this does happen. Assets passing outside your preferences and more. Consider your funds going to the government to consolidated revenue and being spent on things you don't agree with. Best of all, it costs nothing to find out more. So if you'd like to find out more, watch our videos and the others in this series. Email maryjane@freedomffs.com.au, or you can also book online. Mary Jane can book it for you, or you can book online with an appointment with me, and I can assess your initial needs and decide whether I can recommend what you need or whether you need to go and talk to Grant as our estate planning specialist. So thanks for listening. I hope that wasn't too difficult to follow. It is very complicated information, and that's why we are putting it out there to help people. And if it's too complicated and you don't understand, just come to us and we will be able to assist you. Thanks for listening.